Hi, I'm Kathryn Grace Jordan, founder and president of End Discrimination Now, coming to you from our national headquarters here in Manhattan. I established this organization 20 years ago when I realized that corporate America was not abiding by federal and state discrimination statutes. I also realized that the courts were not enforcing the laws. And when I realized that federal agencies like the EEOC were not effective in dealing with the issue of discrimination, and that the Human Rights Division was of limited effect. So we decided to do something about it, and that's why we founded End Discrimination Now. Why is discrimination important? Well, first of all, diversity is absolutely fundamental to a democracy. Democracy is built around the concept of diversity. This country was built around diverse people of various countries. And it is vital to our future that we protect this diverse culture. The other factor is that diverse corporations are more successful. There are many, many studies that have done that prove that excellent corporations are diverse corporations. So the rebuttal that discrimination is expensive or that it gets in the way of profits is simply not correct. Another reason that people don't realize why discrimination is important is that the vulnerable of society must be protected. A lot of people don't know this, but when Hitler, during World War II, executed the final solution that resulted in the extermination of 9 million Jewish people, he didn't start with the Jewish population. He started with the disabled. And it was all based on a paper that was drafted by Dr. Goebbels, a paper entitled Leben Wirchen Leben, which in German means life unworthy of life. Hitler felt that anybody who wasn't perfect should be exterminated. And so he started with the disabled. 9 million people were systematically destroyed as a result of that philosophy of life. And that's something, one of the reasons why discrimination is so very, very vital to our society, why we have to vigorously protect our discrimination laws. In bad economic times, we often see a lot of hate crimes, racial profiling, and reactive transference of rage onto protected classes. We have to be especially sensitive during these periods. So what do we mean when we talk about discrimination? Well, when I talk about discrimination, I'm talking about all protected classes and the various statutes that protect them. Whether it's the Civil Rights Act, whether it's Title VII, whether it's the Age Discrimination Act, ADEA, or whether it's the Americans with Disability Act, or the Equal Pay Act. There are a number of federal statutes that protect protected classes. Those were put into place for that purpose. And it's up to the courts to make sure that those laws are enforced. Unfortunately, the courts have not been doing their job. We have to ask ourselves whether we're winning the war on discrimination. And the answer is absolutely not. We're definitely not. We're losing. And I want to explain why I believe that. We monitor the EEOC reports and the statistics that are published. We monitor the State Division of Human Rights. We monitor the U.S. Department of Labor and Statistics data. So we know what's going on. We see trends as they evolve. And we can tell you that what's happening is minorities and women are stuck. They're stalled. They're in the middle class of corporate America. They're unable to get past the glass ceiling, or as I like to put it, the concrete ceiling. And if you look at the hiring patterns of corporate America that are published in the private sector, published by the EEOC, you can see what we call a discrimination index. And by that, we measure the representation of different protected class groups indexed against their representation in their composition of the marketplace, the employment marketplace. And the patterns that we see are the following. We see minorities, Hispanics, African Americans, and even Asians, making advances in the middle class. But we see a stark contrast when you look at the executive level. Here, white males continue to dominate, females continue to have a secondary role, and minorities are being boxed out. When we're talking about the disabled, the picture is even more bleak. They are what I call the invisible class. The rate of unemployment among disabled people is twice that of the population. In general, unemployment's around 8.5%. The unemployment rate among the disabled hovers between 15 and 16%. So corporate America is simply not hiring disabled persons. I also happen to know they're not accommodating them, which is the law. Corporations refuse to accommodate, in many instances, a disabled person because it is expensive. Ironically, a lot of these expenses are tax deductible. We also have a problem with older workers who are expected to disappear. And there's no obligation on the part of corporate America to providing older workers with pensions that they've earned, or the promotions, or the equal pay for the same job. And in a little while, I'm going to talk about a case involving older workers, Stevenson versus hotel employees. It's a real problem because we, on the other end of the spectrum, we have a lot of unemployed college students who have every right to come into the workplace and have a job. They went through college, they paid the expense and the time to develop those skills, and they deserve the right to have a career. So there's no question that there's a dilemma here. The question is how it's solved, whether we solve it legally and ethically, or whether we solve it illegally and unethically. We also see equal pay laws circumvented. Women still make 70 cents on the dollar compared to men. That's hard to believe in 2012. So we don't have any Ninth Circuit knights to clone anymore. I'm going to talk about why that is. First of all, corporate America will not self-regulate. This is not in their interests. It is costly and expensive, and it's a drain on corporate resources when corporations do not follow diversity laws. There are loopholes in the laws, and more often than not, what will happen is a corporation will hand off an EEO matter to outside counsel. They will use it, the lawyers, to gain an unfair advantage in our dysfunctional court system through loopholes in the law. The most important problem, though, is at the court level, where we find that federal and state anti-discrimination statutes are simply not being enforced. This is extremely serious. Harvard Law School did a study in 2009 on the affirmance rates of various courts around the country in terms of discrimination cases. And they found that the reversal rates for corporations versus the reversal rates for individuals, there was a 5 multiple factor difference. That 41% of corporate cases were on appeal were sustained, while not only 9% of individual cases were. This study basically attested to judicial activism. And it's based on a number of biases that corporations have that have no basis in reality. And I'd just like to speak a little bit about the fact that I worked in corporate America for 20 years as an executive. I am an eyewitness as to what's been going on. And when somebody files a discrimination case, there is a perception by judges that these people are either vexatious litigants or liars. And that is part of the reason why 95% of federal cases are dismissed. 95%. And 95% of the EEOC complaints are found no probable cause. I do not believe that 95% of the people who file these complaints are liars. I do not believe that 95% of the people who go through these kinds of agonizing litigations are imagining that they've been discriminated against. I believe we have a broken system. The agencies that are charged with enforcement of the laws do not fare much better. We have the EEOC, the Human Rights Division, and we have the Judicial Conduct Commission that's supposed to be regulating the courts. So let's take a quick look at what's going on with some of these agencies. Let's start with the Equal Opportunity Commission. The Equal Opportunity Commission is a failed organization. It is a humongous $385 million budgeted agency that has failed repeatedly to enforce federal and state discrimination statutes. Their mission, if you look at their strategic plan, is to combat employment discrimination through strategic law enforcement, prevent employment discrimination via education and outreach, and deliver excellent service via a skilled, diverse workforce. And that all sounds very good, except when it comes right down to it, the EEOC does, what the EEOC does is basically settle cases. The problem with settlements is that settlements do not benefit the employees. They benefit the corporations. And the litigants are never made whole. Most of the settlements coming out of the EEOC and the State Division of Human Rights, on average, are $2,500. That does nothing. That doesn't make a dent in the damages sustained by these individuals or in the compensation lost. Again, we had a 21% rise in charges in the last EEOC report over 2007. Yet, the no reasonable cause rate was 66%. That was up to 10% over 2007. What that means is that when the EEOC went to President Obama and asked for an additional $31 million for their budget last year, or it was the year before, they took that money and basically settled all the cases, the extra cases that were on their books. And they also found that the majority of the cases were not reasonable cause. The reasonable cause rate for the EEOC, I don't know if anybody can guess what it is, 4%. I do not believe that only 4% of all the complainants that visit the EEOC are telling the truth, and everybody else, the 96%, are lying. In fact, I think that the amount of complaints only represent a fraction of the people that are actually being discriminated against, because most people don't file discrimination complaints because of fear of retaliation. Job hiring patterns, which we've discussed a little bit here, and which we have a chart that I will show you shortly, prove that protected classes are trapped in this concrete ceiling. Why aren't discrimination laws being enforced? This is the big question. And it's a complex subject, so bear with me for a second while I explain it. First of all, our court system is simply not working. We don't have the resources to handle the number of cases that are coming into the courts, and the judges are completely overwhelmed. One of the reasons is that the courts are addicted to quickie settlements. Quickie settlements do not make litigants whole. Quickie settlements subvert the purpose and intent of federal and state discrimination laws. You don't get a verdict, and because you don't get a verdict, the laws are not strengthened. You don't get make-whole damages, which means that the litigant who has been damaged and who under the law should be remedied never is. It is basically the only party that benefits from these settlements are corporate America. That's why corporate America and the Bar Association fights so very hard to keep judges around and to nominate judges for advancement that are for these quickie settlements. The second thing is that under our current system of judicial advancement, which is handled by the Judicial Nomination Commission, judges are advanced based on basically large corporate law firms. Because they are advanced by large corporate law firms, they have a bias toward corporate America, and they often find themselves in a position of doling out favors to them with the expectation that when they dole out these favors, they will receive a favor in return in the future come nomination time. This is an insidious, dysfunctional system that must be completely reformed. The third barrier, is that a lot of judges simply don't understand the legal standards. I cannot tell you how many times I personally have had to correct the legal decisions, the legal standards that have been relied upon by judges in decisions. Sometimes they deploy outright fraud. I'll get to that in a minute when I talk about some case histories. Another barrier is was a decision that was inadvertently created by the passage of the Twombly and Igby cases, which were intended to help judges surgically trim their dockets. These cases provided the courts with a mechanism by which they could determine whether or not a complaint was, quote, plausibly pled. And if the complaint did not have enough facts pled, the complaint could be dismissed as a matter of law. And to be very honest, there are lots of complaints that come through the court system that have no basis in fact. Unfortunately, though, there are a lot of judges out there who don't have a sufficient knowledge of the legal standards or intentionally disregard the legal standards and have used this particular standard to indiscriminately dump pro se cases. When judges dump pro se cases, they are systematically discriminating against protected classes. Now, it's true that discrimination cases are hard to prove, and the U.S. Supreme Court is very conscious of this and has, over the last 5 years, gone out of their way to rule on a number of major discrimination cases. I believe the U.S. Supreme Court has done its part in trying to clarify standards. The problem is not at the U.S. Supreme Court level. The problem is at the appellate court level, where judicial activism is rampant. Now, I want to talk about this because it is the biggest problem that stands in the way of the advancement of protected classes. This is a systemic bias that's in the system. Now, I'd like to talk about why that bias exists, because it's not by accident. The bias exists because a lot of judges who lead very insular lives inside the judiciary, inside courts, who have never worked in a corporation, in the private sector, have a very abstract, unrealistic concept of what is going on in the workplace. And many of them don't keep up with the social journals that would enable them to understand these problems better. So I'm calling out to the judges out there to take more time to stay abreast of trends, to get a better understanding and not rely on biases. Many judges will mistakenly believe that if a litigant shows up in their court more than once, that that's a, quote, vexatious litigant, when in fact, maybe the person falls into a high-risk group. Many people fall into multiple classes. For instance, an older Hispanic woman would be in 3 protected classes, and one would expect that that individual would be at 3 times or more the risk of discrimination. So one should not be surprised if that individual shows up in court on a more frequent basis. The same thing goes for people with disabilities, where they often run into myriad accommodation problems. So we have this epidemic of judicial activism that is also a problem. One of the reasons that judicial activism is so prevalent and has grown over the years is that it is perceived to be linked to advancement. There's a lot of reality to that, because when a judge goes to, starts to think about their next promotion, they're thinking about how they can impress corporate America's law firms, the large law firms that nominate judges to the Judicial Nomination Commission. So the entire nomination process perpetuates the cycle of discrimination. We have an unlawful expansion of appellate powers. We have appellate courts, instead of enforcing the laws, instead of backing up the trial courts, we have them reversing these decisions on appeal. So we have judicial activism acting to subvert the laws. Now, one would think that judicial activism would be reined in by a regulatory agency. And we do have a Judicial Conduct Commission whose goal is to do exactly that. Unfortunately, the Judicial Conduct Commission is not working. It's not an effective entity. And let me give you some statistics. This comes out of the 2011 annual report. In the Supreme Court alone, 322 complaints were filed against judges. Only 11 of those complaints were investigated, and of those 11, only 3 judges were disciplined. At the appellate level, it gets even worse. We have 69 complaints filed. That's a significant increase over a couple of years ago. Only 4 were investigated, and 0 were found when there was a determination of a need to discipline the judge. So we can safely say that the Judicial Conduct Commission is simply not doing its job. Now, there are also financial reasons that are complicating the picture. Corporate America can write off their litigation expenses. Individuals cannot. Corporations can buy the best lawyers. Individuals are lucky if they can get a lawyer. So all of that has to be considered when we talk about judicial reform. We are also looking at, because they can write off the expense, corporations don't look at this as high risk. And this is especially true when you're looking at multi-billion-dollar corporations who can afford to write off these liabilities. They don't really see it as a risk. They see it as a rounding error on their balance sheet. So, if anything, the judiciary isn't being strong enough in terms of really affecting large enough damage awards that will make it sufficiently painful to deter this kind of conduct. We then see the wrong kinds of judges being advanced. There are a lot of people out there that think we should just pay private sector compensation. In fact, Judge Littman and Judge Kaye filed a very big judicial compensation lawsuit a few years ago. And in it, they made a number of declarations and demanded that private sector compensation be paid. The only problem is, when you start paying judges the same as you do a private law firm at one of the top 3, you're basically getting into bidding wars, and you're attracting the wrong kind of person. We happen to support judicial compensation increases, We believe judges should be paid a fair salary so that they can live and function at a high level. The other problem with the wrong kinds of judges being advanced is that we have weak, underqualified judges being advanced by partisan interests. We talked about the nomination process. The nomination process allows this to happen. We also look for the wrong criteria in judges. We're not strict enough about scholarship. We need really smart judges because the law is getting more complex every single day. Just the digitization of the marketplace has made it such. And we have global forces that are changing the world as we speak. We have to have judges that are highly, highly educated. We have to have judges that have strong ethical values. So these are all things that have to be considered. Most of all, we need strong rule of law judges. We don't need politicians in office. We don't need policymakers. We don't need liberal judges or conservative judges. We need judges that are impartial triers of fact, strong rule of law judges. So I want to talk about 3 case histories that bring to life this issue. Stevenson versus hotel employees, and Kathryn Jordan versus Bates Advertising, and Kathryn Jordan versus Verizon Communications. I'm putting it out there. I'm opening myself up to scrutiny with the confidence that I know what happened and I was an eyewitness to everything that went on in these situations. Stevenson versus hotel employees was a case where a couple of older workers, white men in their 50s and 60s, won a big discrimination case against a union employer. They got $1 million in punitive damages. On appeal, the First Department, Judges Andreas and Sachs, and some others, reversed that decision. It was the basis upon which they reversed it that was so shocking. In this case, the employer admitted in the record that it was their intention to replace all the older workers with younger ones. Now, when you see evidence like that, and you're a judge, you do a little dance, because that's called direct evidence of discrimination, and it's called case closed, pretty much. In this instance, on appeal, the judges decided to apply the, quote, nov defense, and to claim that there wasn't sufficient evidence, that the level of, it's a sufficiency defense. This is done on a very, very wide scale in all the appellate courts now. Unfortunately, they didn't apply the law accurately. And they decided that because the employer, who had retained Kroll Associates, an executive consulting company, to advise them, Kroll had told them that the plaintiffs were, quote, bagmen for the mafia. And the panel were so startled by this allegation, which was subsequently disproven, that they discarded all the evidence against the employer. And they said, okay, well, the employer retained 3 people that were young, and fired 3 people that were young at the same time, and they retained 1 older worker. The problem was the 3 people, younger people that were fired, were indicted. They were indicted in this criminal investigation. The older person that wasn't fired was not indicted. So there was no pretext. In other words, the corporation's pretext failed as a matter of law. So that case should never have been reversed on appeal, and it was. When that case went before the Court of Appeals, where Judge Kay and Judge Sir Patrick, surprisingly, were given a decision by Judge E.B. Smith, they had an opportunity to scrutinize the majority's erroneous, clearly erroneous factual findings, legal findings. Instead of doing so, they sustained the appellate court's decision. And part of the reason why this happens is there's a follower mentality that a lot of the courts get into, especially at the appellate level. It's like, well, this appellate court below me said this was okay, so it must be okay, and I don't want to tread on their feet because of political reasons. And truthfully, most appellate courts are not supposed to second-guess the trial courts because of the abuse of discretion standard, which requires that the evidence be viewed in the light most favorable to the prevailing party. That standard precludes the ability of appellate judges to reverse jury verdicts. It makes a jury verdict pretty much rock solid. Yet we see activist judges on appeal reversing these cases. Now, I experienced this direct hand when I won a major perceived disability discrimination case in 2005, after waiting a decade for the case to get to trial, and after a federal judge had dismissed it in federal court because the complaint wasn't notarized. It had been filed on time, it wasn't notarized on time, and the EEOC had a big furlough and snowstorm, and I had a broken leg at the time. It wound up in state court. I won the case after an 11-day trial. The trial court judge, Judge Acosta, sustained the jury verdict in a post-trial JNOV challenge. And unfortunately, the trial judge got derailed on a contingent legal fee deal with the lawyers. On appeal, Chief Judge Lippman and Judge Gonzalez and Friedman and Catterson and Sullivan, an all-white, all-male panel, Judge Gonzalez is Hispanic, reversed that decision, a decision that I worked my whole life for, that I sold 2 homes for, that I gave up my life savings for. And I did it for one reason and one reason only, because it was the right thing to do, because millions of people needed that decision. Now, for Chief Justice Lippman, he reversed it because it got in the way of his succession plan, which involved Judge Acosta. And he didn't want any pesky little investigation to interfere with that. The other thing that Judge Lippman had in his agenda was he wanted to change the legal standard for discrimination cases. Instead of following McDonnell Douglas, they followed, ironically, the Stevenson case that I just described, which was completely wrong. Judge Lippman did this because he wanted to change the standard from the tripartite standard, where you not only the plaintiff presents the prima facie case, the corporate employer rebuts it with a legitimate reason, and then the plaintiff comes back and proves what the motives of the employer were. Judge Lippman basically cut off that third leg and said, okay, all an employer has to do to rebut a discrimination case is simply establish a legitimate reason. In other words, let's say you're a victim of gender discrimination and you file a complaint. All an employer has to do is say, no, we didn't file her because of gender. We fired her because we had, quote, financial problems. Well, is there a company out there right now that doesn't have financial problems? But this is what Judge Lippman believed and accepted as significant and admissible evidence to rebut a very solid prima facie case, where the employer, in my case, swore under oath that he had heard other people, other executives, refer to me openly as a cripple. And where I testified that I had been hazed about the need to ambulate with a cane. This was rock solid evidence. And Judge Lippman reversed the decision. That was in 2007. And since that time, I have been trying to get that decision vacated, because he unfortunately acted without jurisdiction, as did the trial court judge when he entered the final judgment. Now, there was one other case that I was involved in on disability, and that was against Verizon. I went from the frying pan into the fire. And there's two ways of looking at this situation. One way is to say, oh, wow, you've reached your lifetime cap of one case, and anyone that appears before us more than once must be lying. Or you can look at it in terms of what's really going on. And that is, there are people that are at high risk. If someone is an older Hispanic woman, that person's in 3 protected classes. That person is at multiple levels of risk, exponentially more at risk than a white male. That person will be targeted for discrimination. And that person will show up in your courtroom more often than the white male will. It's up to the judges out there to start to think and not react emotionally, not rely on outmoded models that no longer apply to the workplace, and to read up more on the social journals. Okay, so I just want to wrap up here in terms of a couple of thoughts, recurring themes. There's something called blame the victim, and it's a model that was developed, I think it was back in the 70s, where it was finally recognized that a lot of the times people blamed victims for horrific situations that occurred in the workplace. They didn't hold the employers responsible. They didn't step back and say, gee, this employer had billions of dollars and could have prevented this from happening and should have had a safe workplace and should have had EEO manuals all over the place. No, they didn't say that. They blamed the victim. Make-whole damages are the only way that we can both punish the employer and deter future repeat conduct and make the victim whole. These two concepts were developed 30, 40 years ago, and they're not being applied. Judges simply don't think in those terms, and they need to. They need to start making victims whole. They need to start taking cases to trial. Now, when I say that, I know alarm bells are going off in these courtrooms because these judges are overwhelmed with their caseloads. No judge should have to take 1,200 cases a year. There is a solution. We're working on it in the sense we have proposals. We'd like to share some of those ideas with decision makers in Washington and Albany. We know how these problems can be solved. We know how you can balance pro se litigants, the needs of all these pro se cases without dumping them, as Chief Justice Lippman did when he first came into the office back in 2008. You don't have to dump cases. There are ways to strategically shape a docket. The other concept that I want to talk about is the denial of due process. There's nothing more destructive that's going on in courts today than the denial of due process. Courts not allowing people to even notify of hearings, being denied the opportunity to speak, being sanctioned when they speak, not being allowed to make a decision about representation or not represented. These are all due process issues, and this has to stop. Judges must embrace due process. Now, I alluded to the Verizon case, and I want to talk about it really quickly, and then the ADAM number is going to go up. When I was at Verizon, I was an executive. I was in charge of the branding, naming operations, and I did work with them during their worst period for the company. We went through 3 mergers, the launch of the long-distance business, the launch of the Verizon brand, and numerous subsidiary entities and various other new product launches. I worked 12 hours a day. I did the work of about 10 people. After about almost 3 years of this, I basically collapsed, and my collapse was related not just to the work, but to the circumstances under which I was required to work. I was again subjected to this whole cripple thing. I was denied accommodation. I was made to humiliated over the need for accommodation. I was put on probation for 2 years. I was subjected to endless 360s and PIPs by people that had no idea what they were doing. And I was told that the accommodations were being withdrawn as punishment for not meeting PIP goals. And I can assure you those PIP goals were rigged. And the 360s were altered so that it was distorted and so that the employer looked justified. Now, I'm speaking to the judges right now. There are lots of signs that you should be smart enough to recognize when you see a case. A lot of trigger points. And when a corporation, a large multi-billion-dollar corporation, consistently violates the laws, and Verizon was, after my case was denied, I was never allowed to go to trial. I was coerced into an involuntary settlement under the threats of litigation and sanctions. After that happened in 2004, 4 years later, Verizon was hit with an $80 million class action disability discrimination case. And they paid a $20 million settlement. That's karma. But for judges, I want you to reach out to you, and I'm going to ask you, remember why you became a judge. Remember the oath you took. Start looking for those signals, for those warning signs. Don't believe when somebody says to you, she's a vexatious litigant or he's a troublemaker. Don't believe that, because that's what lawyers are paid to do. They're paid to concoct spin. You're not that naive. Read the journals, study the patterns, read the EEOC reports, stay in touch, stay connected to the market, know your craft. But we also know that unless we have new leadership in the judiciary, and we have tough rule of law judges at the top that lead by example, that there's nothing that can be done that will change the outcome. So again, just to recap, there's definitely a problem. The discrimination continues to be pervasive, despite the best intentions of various decision makers. And we would urge the president to establish a multi-stakeholder judicial reform task force and a multi-stakeholder discrimination task force to address these issues. Thank you for your attention, and we will post the 800 number at the end of the film. Thank you.